Thank you very much, sir. Thank you for that wonderful insights. Before we get to the next person that is going to speak, that is on this matter, you alluded to the fact that erroneously people have gifted you with the 1999 Constitution, and you said is an honor you would gladly accept. Now, please, may I ask? I mean, you've clearly said you did not author the 1999 Constitution. My question to you directly will be, what is then your role as it concerns the 1999 Constitution, sir?
All right. Well, I can see, I was reading through the charts that there are still some people who are so hell-bent on christening it that I do the Constitution. As I said, I accept it. Now, my role, as I said, you remember in 1994, there was a constitutional conference which led to the emergence of what was popularly referred to as the Abacha Constitution of 1995, but which was never promulgated and actually was thrown out. But when General Abacha died and General Abdul Salam took over, he retained me as a legal advisor to him. And within that 1 year that he was in office, the need was felt, and he didn't want to stay longer than 11 months that he has said he wanted to be. A constitutional debating committee was established, chaired by late Justice Nikki Toby. I remember a number of names that were on that committee. I was one of them. I can't remember the names of all others who are on that, but there are 49 members. Now, that committee went around and sought the views of Nigerians. At the end of the day, it reported that there was an overwhelming support for a return to the 1979 Constitution, an overwhelming support for the return to the 1979 Constitution with necessary amendments. So really, what the PRC did, so you're asking what my role is. Yeah. I had no role in writing anything. I was only part of the committee chaired by Justice Nikki Toby, which submitted a report to the PRC, which adopted its recommendation that we go back to 1979 Constitution. And the structure I laid out to you actually is 1979 Constitution with necessary amendments. Necessary amendments such as the fact that in 79 we had 21 states or maybe 19 states. In 1990 we had 36. We didn't have NJC. In 79, it was introduced Nigeria Judicial Commission. But the straight answer is that it will be silly of anyone to say that I wrote that Constitution. In any event, as I said, that Constitution is reflective of the basic structure I outlined. Did I author chapter 4? Did I author chapter the section dealing on judicial and executive powers? Did I author all those other sections? What exactly in 1979 did I author that is new? Maybe I will even take credit for introducing not less than 13% that is given on derivation, which is one of the few things, new things in the 1999 Constitution. So that's your answer, my friend.
Okay, thank you very much. Here, I think it's been cleared, and I want all the press in this room, in this conference this evening, to take note. I think the professor has cleared this now that erroneously had the report. I mean, I've read that report myself online, so now he's cleared the air. Hopefully, after this conference, that's not going to be attributed to him anymore. So Daniel, over to you. Do we need to bring in now Professor Chidodin Kalu before we start taking questions?
Please, if you will oblige me, the Professor Yadudu has indicated that he will only stay briefly. So if I ask Professor Kalu if he's here to wait to tarry a while, let's see some questions, whether some people will like to ask Professor Yadudu some questions before he leaves.
Okay, that's fine. Are there questions directly being directed to the professor before he takes his leave?
Yes, there is a question someone sent in the chat room. He says something in the form of what the professor thinks are the weaknesses of the 1999 Constitution. What defects would he like to be corrected in the 1999 Constitution?
Prof, over to you, sir. You had that.
Well, I'm not a political actor. I see a few problems with if you give me the opportunity, I would want to see the amendment process a bit more relaxed. In particular, the role given to the presidential assent. To me, if you go through the process of amending the Constitution, the National Assembly does it, the public hearing takes place, the amendment goes to states' House of Assemblies, which are adopted by 2/3 support, and then it comes back, and then it goes to Mr. President, and by a stroke of the pen, the President strikes it down. I think that is wrong. And it is not in the spirit of a presidential system that even in the US, amending the Constitution should not give a veto power to Mr. President. I would like to see that changed. I would also want to see, there is a problematic area of the redistribution, devolution of powers. We've been battling with how do we devolve more powers from the federation to the states. Now, I think in the last few exercises, the one I have been involved in, for example, in 2014 and 2005, and also in previous exercises, the attempt was made to devolve a few more powers to the states. Now, unfortunately, if you are running two lists, the concurrent and the exclusive list, even if you give states powers under concurrent list, the federation can cover the field, and therefore when the federation legislates in those areas, it still takes away the power of the states to do so. I think there is a lot of areas that needs to be amended also to deal with electoral inertia that we have, the electoral reform. There have been recommendations that the INEC made, and I think Justice Ways Committee met. And I think if we can look at those. Now, as I said, maybe that is my 2 pence in terms of what are the areas of the constitutional amendment. It is tempting for some to want to bring some clarity to Section 10. I think in my view, it is best left in the nebulous language. If we want clarity, it is best that we test that through the judicial process and not by introducing any new language. You may introduce language, any language you introduce subject to interpretation, and therefore you cannot solve that section by expanding or contracting the language.
Okay, thank you very much, Prof. There is another question here by Collins Okpara. He says, Professor, what is your position on the exclusive list and the concurrent list?
Oh, I just said my views on it. It's just that I wish in the 1960 constitutional amendment, I think there was some implicit language that there was a residual list. Now, I would like to see some tinkering done, some thinking put into creating more explicitly anything not listed in the concurrent or the exclusive list belong to the residual list, and we can reduce the concurrent list. so that if you create an explicit in the sense that anything which is not in either of the lists belongs to the residual list, meaning belongs to the states or the local governments, I think that may give more room for localities to legislate, to exercise powers, and to release the kind of energy that some had alluded to. So that's my idea. Create a third list, reduce the two lists, implicitly create, or rather explicitly create a residual list that belongs to states and local governments.
Okay, thank you very much, Prof. Another question from Cozy Williams. He says, do you favor introducing a constitutional court that will be separate from the current constitutional, from the current court?
Yeah, I think both in 2014 and also in 1995, there was a proposal for the establishment of the constitutional court. My problem with constitutional court is that, one, you'll be creating one court too many. It is the same thing as my objection to creating electoral offenses tribunal. The other thing is that there is going to be a problem in the jurisdiction because what kind of jurisdiction would you be given to it that you take away from the existing courts? And how would the existing courts also resort or react to that? Because it has happened, don't forget, in 1976, when the Federal Revenue Court was established, the present Federal High Court, there was so much contestation between the state high courts and the Federal Revenue Court, so that there was inertia and there was confusion. So to me, I don't think creating a constitutional court in the language that I think in 2014 it was introduced, also in the language that it was introduced in 95, may solve the problem. It will only create one more judicial avenue that is not terribly needed, and that will be in contestation with other courts, just like the industrial court. I think it was wrong to have created the industrial court and to have made it part of the constitution of Nigeria.
Okay, thank you very much. I think before you go, we have one more question from Chidi. Chidi, you're on. Can you please ask your question now to the Prof?
Thank you. The name is Chido Onuma. No, Chidi, this thing. Yeah. Thanks, Prof. Just wanted to go back to the question you raised about the fallacy of imposition of the 1979 Constitution.
Yes.
As one who took part in that, how much influence or interference, for want of a better word, the political class who were going to implement that Constitution, did they get to see any of what they were going to implement? That's on one hand. Then secondly, you raise the issue of power sharing and by extension the sharing of resources, which I think is at the heart of the whole debate about review of the Constitution. Why do you think there is a problem where you have a Constitution, for example, it not only legislates the states, but something as simple as local government? As far as I'm concerned, I think it puts an end to development. It means for states to even create their own local government, they have to go back, the Constitution would have to be amended. What's your take on that?
Oh, okay, well, I think that for the first question, I think in 79, really the one thing that you could say there was a heavy dose of imposition was the inaugural address of late General Murtala Muhammad, who clearly left the 49 wise men no choice but to propose a constitution that was not parliamentary in nature. And therefore, they took the brief and we shifted from parliamentary system to the presidential system. I think his address was very, very clear what they wanted. And I think there is a good case for having a central, an executive system, a president elected centrally, universally, and what have you. So this is one area I see what you can say was a preference of the military as to the direction of things. Of course, you remember when there was also this noise, the Sharia controversy and the boycott, and then of course, President Obasanjo then, or maybe the head of state, told them to take their hands off that, and it ended up, of course, not introducing the federal Sharia Court of Appeal, but introducing some kind of accommodation of the appellate powers of both the Court of Appeal and the Supreme Court to accommodate judges that may come from, or appeals that may come from the Sharia Court of Appeal of the state. And then, of course, there are these clear fingers of the military on the 1979 Constitution, having regard to those decrees that were made part of the part of the Constitution, which was no decision of the Constituent Assembly members, the NYSC, the NSO, the Land Use Decree, and maybe one other thing. So those are the areas that I can clearly see what you can attribute to the military. And having regard to the second question about a local government, I think again, if we are very, very if we are able to create a consensus, the language of the 1999 Constitution have regard to how you create local government areas is such that it leaves matters to the states. Only that when they do that, it becomes incoherent, as the Supreme Court had decided, until the list that had been entrenched in the Constitution has been changed. So my view is that it is not that the Constitution is really legislating local government system as such, but the process of their creation and also the process of their final takeoff is one that requires national consensus. That is to say, the adoption of the proposal by the National Assembly. So you can relax that too, but I think it is something that we can. I don't know, we can live with, and by the way, governors don't want the powers that are now in the Constitution to be taken away from them, because they want local government to be given to them, and they deal with it as they wish. So it's not the issue of the choice between the federal strictures as against local flexibility. If you go local, it's going to be like another state electoral commission. So you know what happens with the state elections.
Yeah, thank you very much, Prof. I think Dr. Sama Mabi is about to leave. So we take one more question from you, then we can go back. So we have the last question for you, Prof. That is Ejikeme Ozal. Ejikeme, you're on now. Please go ahead. Make your question very snappy, then we can go back to Dr. Sama Mabi.
Yes, thank you very much. Please put me on the video. Thank you very much, Professor Yadudu. My question to you is, number one is, how would you like the restructuring to take place in Nigeria? And secondly, why did the Sovereign National Conference report delayed to be submitted to President Goodluck Jonathan, and then it runs near to election? There is a general feeling that you intentionally, delayed it or an obstacle to the submission. How would you plea, please. Thank you.
Okay, plead. Am I being charged before a court of law or what?
No.
Anyway, not a problem. Not a problem. My reaction actually, your first question actually is I have no particular view as to what restructuring should take place in Nigeria. All I am for is that I think Nigerians have a legitimate interest to discuss any issues, to agree to any sort of ideas, and including dismembering the country. But this is a big but, there is an existing legal order. It has to be done within that legal order. Otherwise, it is chaos. So I do not have a view as to how I want my state Kano to feature in a federation or confederation of regions or zones. But whenever you call me for a discussion, I'll come to it, and then we agree on issues. I would want it to be implemented one way or another. Now, I think you got your facts wrong about, first of all, the 2014 conference was not sovereign national conference. It didn't have sovereign power. It was a collection of individuals that President Jonathan himself put together, so it's not sovereign. It didn't have sovereign powers. Secondly, it was the president himself. The timing he chose was what dictated when and how the report went to him. In any event, if you got your facts correct, we finished the 2014 conference on August 14th, 2014, submitted the report to President Jonathan, I think on maybe first week of September of the same year. So he had the whole year to do what he wished with the report. He did nothing about it. So you cannot accuse, even put me on the dock. Again, maybe as being the cause for why the 2014 report was not adopted, because I didn't want it to happen. It was the president himself who chose the wrong time, and who, even when it was handed over to him on time, he did nothing to implement, not a single recommendation in it. So he just pushed the can to some other people. I think if anybody should take the blame, it should start with his regime. He set us up. We gave him a report on time. He did nothing about it, and the conference was not sovereign.
Okay, thank you very much. I think at this moment it will be fair to bring in Dr. Sama Amadi. Dr. Sama Amadi, can you please unmute, and can you have your view on what the Prof have said so far? Dr. Sama Amadi, can you please unmute?
Hello, are you hearing me now?
Oh yes, we can hear you now.
Okay, sorry, I'm trying to dress up to go to studio, so I'm struggling. Okay, yeah, can you raise a question? Anyway, any question? Yes.
No, based on what based on what Professor
Professor Yadudu said. Okay, I have a couple of responses. First, I think Prof's argument about constitutional, my point about instability that comes from too much constitutional change. Prof will recall that those American amendments to the American Constitution took a lot of years and deliberations. Some of them lasted for about 20-something years. If you look at each of the amendments, they have to go through, because the politics around it, the debate, the politics to create a sense in which people will agree to something like civic right. And some of them came after tumultuous political development, struggle for civic rights, the issues around the powers of the state, the First Amendment, Second Amendment, all of them had a history. It's not like in our own case where instead of 3-man or 13-member senators, they go to the states, you have a public hearing, NGOs file papers, some people like us, interlopers, will go and speak, and they do a voting among themselves based on political convenience. block voting. We know how we got Section 121 reviewed. First, the legislature says no, they go around and talk to them, sign up. So my point is that you need some level of political stability. And then it requires taking out many things. If I was to revise the Constitution, remove 80%, for instance, about election. Some of the provisions we are making the Constitution are things that you make by ordinary lawmaking process. Some of them are even supposed to be by substantive legislation, by agency rulemaking. Those like INEC, basic things about election. Then INEC will have the responsibility to, to rule out processes and so on and so forth. So my argument is keep it simple and stable. So the second point, so I'm not saying that it can't amend. I'm saying that historically the argument is published. There's a World Bank commission by some professors at Kennedy School and Oxford. They did the work on some constitution in the world and reviewed. An argument is that if you make constitutional provisions so easy to amend based on political outcome, then after every election, the winners will demand the right to amend the constitution to respond to their own. So, for example, there's a Green Party in Nigeria, it wins election, or it's a party of socioeconomic rights, it wins election. The first thing will be to make Section 4 constitutional. Then a party of, let's say, liberals and monetarists, the liberals who don't want fundamental rights because of the cost to the economy. With the win power, their tendency will be to create that. Second point that Prof raised about Section 10. Yes, the point I was making, Prof, is that Section 10 is seen to be nebulous. But my point is, when the Constitution says, if you look at the history and the debate around it, notorious famous case Mbakwe against Alhaji Ban at the Constitutional Conference that gave out 1979 Constitution, he discovered that there are two contending viewpoints. One is the viewpoint of what you can call the typical secularists, those who wanted the Nigerian state to simply not be multi-religious. Yes, we are a country of multi-religious, multiple religion, but also a country, the fundamental right in Section 36 says right to freedom of expression, religion, conscience, and opinion. So what that means really is that we don't have to, there are opinions are not religious, just like the case I gave the case of a theist who says an atheist and speaks things that are maybe blasphemous or contradictory to religious faith. So I am of the view, I'm not saying that you must interpret Section 10 to mean that Nigeria is a secular state. I'm saying that there is two opinions. One is the ones that says it's a multi-religious state. Therefore, once you don't make one religion say Nigeria is Islamic or Christian state, then even if you privilege one religion, even if you knock out other religion, then it's okay. I say no, let's move to a neutral state that does not in any way get so entangled. It's a big debate, but that's what I would like to see. Again, on this point also, if you look at like reference to maybe bigamy and others, there are one of the arguments the Professor Auwal made, which I agree completely, is that morality has always been part of law. So, for example, all killing is a crime for both in the law, but also morally prohibited by Christianity and Islam. Nobody quarrels with it. But you can't say that killing is now a crime because of what Jehovah or Allah said. That's the point we're making. You can't make a criminal law in the name of religion. Even if you say it applies to only people from that, because people in that religion can also say they're no longer members. People can say they're no longer Christians or Muslims. It does not sit with the democratic notion of free expression, of the right for people to choose to believe or not believe. The Constitution it says right to believe, right to not believe, proselytize, and say you don't want to believe again. So if you allow for blasphemy, offense of blasphemy, then that's a contradiction. That's the point I'm making. That we can be like Indonesia. Indonesia is over about 80 to 90% Muslims in population. When I spoke with Professor Wahid, President Wahid, once at Harvard, he gave the view that the leaders agreed not to have Sharia, public Sharia as we have today. It's a big debate. It's touchy. We are a conservative people. We are traditional. And many people will fight again. But that's my sense of where we should be going to. The last point I would like to talk about, essentially, the question about Nigerians, whether the 1979 constitution is legitimate or not. I don't take the view that it's legitimate. The constitution is actually requires that people, like the Greek city-state, people will gather and vote for it. It's a valid constitution, but it's a constitution that is full of military orientation and logic. For example, look at things like Chapter 5. We talk about Chapter 4, rights to this and right to that. If you look at those rights, they cut back. The way those rights are rendered useless by provisos are so typical of military. So it's a constitution that responds to the need more for stability, the need for order, rather than the need for freedom. And that's a debate we have to have. Where do we want to go to? Do we want to have more freedom? Or do we focusing about, for example, the police can actually kill you, shoot somebody dead in order to protect a property. Most of the things we talk about, unfair policing and extrajudicial killing, are arguably justified under the Constitution. If you look at how useless the right to life and right to personal liberty is being rendered by those cutbacks and those caveats. So I would argue that, yes, I agree with Prof. Yadudu that maybe it's not an illegitimate, it's not Yadudu's constitution, no doubt about that, and is still legitimate even though we the Nigerian people did not come and see that in one place and write it. But the question is, the choices the constitution made in the conflict between freedom and order, freedom and maybe national security, and how it defines national security. If you look at many provisions, for example, gender issue, women are talking about the right to have discrimination in terms of who can be a citizen, whether a spouse, whose spouse can be a citizen. There are many issues there. But I want to stay at the major issue, which is first, resolve the nationality question. Like Chido wrote, we're all Nigerians. The question is not about Biafra or no Biafra. Biafra was created by Nigerian failure, and that failure started in 1959 Constitution, what I call the original sin. Nigeria needed to choose to be a democratic secular state or chose to be a neo-feudal theocratic state. And that's why the outsized role of traditional rulers, especially the Sultan, the Emir, the Oni of all these people, religious leaders in democratic leadership in Nigeria is there. Is guaranteed by that choice to be a state that panders more to political, ethnic, and religious exceptionalism. We carve out, we create dispensations, privileges, and prerogatives to individuals based on their identities, ethnic, religious, or their pedigree, instead of creating a society of equality. So I'm unashamedly for democratic citizenship, and I'm an egalitarian. I want a state that can be constructed based on just simple link with a geopolitics, civic link, that's all. And so I'm unashamed to say that I think the Nigerian constitution is not a constitution that's good for a democratic modern state. It's a constitution that continuously creates the centripetal, or is this figure now, forces for conflict all the time, because we're going to be struggling for who wins supremacy between ethnic and religious enclaves. I think that would be my response to Prof.
Thank you very much, Dr. Sam there. And I will want to bring Professor Yadudu back, but I want to remind us all that the conversation happening this evening centers on the coronavirus pandemic, good governance, restructuring, and the 1999 Constitution. Now, in view of this, bearing that in mind, how do we use this coronavirus pandemic period to advance good governance, to push for restructuring, in view of the 1999 Constitution, as has been alluded by Professor Yadudu, that everything we do, we must have to remember that it has to be done within the 1999 Constitution. Professor, over to you now. Can you please unmute?
This is supposed to be a conversation of three. I've been patient. I've been on for 40 minutes. I don't think it's wise or it's proper the way you are handling the conversation. Please.
So who is speaking?
Mahmoud, please.
Go on.
I think we should concede to others.
No, we were only giving you time because you said you just finished fasting, that you're about to leave. So Dr. Amadi is also leaving. So
I have nothing to add really. I'm happy that I've been part of the conversation, and perhaps I'm not in a position to talk intelligently about coronavirus and how really we can do things to it within the constitutional system. But thank you for the opportunity to be part of the conversation. Thank you.
Okay, thank you very much, Professor. And